Here at home, a civil lawsuit will move forward in connection to the death of Amir Locke. The 22-year-old was fatally shot during the execution of a no-knock search warrant in Minneapolis 2 years ago. A federal judge today ruled the case filed by his parents can continue.
Attorneys for the city and the officer tried to dismiss the case last fall. Callan Gray joins us now with the decision. And Callan, what comes next?
Amir Locke's family announced more than a year ago they were suing the city and Officer Mark Hanneman, who shot and killed Locke. They argue Locke's constitutional rights were violated. Now a judge says they can move forward with the suit because the officer and city's reason for dismissing it, the judge says, doesn't hold up.
In February 2022, when Minneapolis police executed a no-knock search warrant, body camera footage shows officers enter a downtown apartment, yelling before kicking a couch. Video shows Amir Locke rising off the couch, and a still frame from MPD shows he's holding a gun pointed down before Officer Mark Hanneman shoots and kills him.
In this particular case, right, the officers go in, they have to make a split-second decision about whether they need to use deadly force to protect themselves or not.
And Mitchell Hamlin School of Law adjunct professor Rick Petrie says the court typically protects officers through the qualified immunity defense.
If you have to make a snap decision, as long as it's grounded in some sort of logic, then it's probably going to be okay.
But a federal judge says in this case, Officer Hanneman is not entitled to qualified immunity. Citing the criminal complaint, the judge says, quote, Amir did not point the firearm at officers or use the weapon in a menacing way and was attempting to comply with officers' commands. He writes the allegations plausibly show, quote, the violation of a clearly established right. The Locke family had sued, arguing his Fourth Amendment right protecting against unreasonable searches and seizures was violated. Family attorneys in a statement today saying this ruling marks a critical step forward in the pursuit of accountability and justice.
You've already kind of got a heads up that, this judge is not really thinking that qualified immunity should apply, at least not yet. That could be a basis for the parties to come together and talk about, maybe we should settle, maybe not.
Petrie says it's unusual this decision came so early in the case. And in his experience as a lawyer, typically it goes the other way.
It's a bit refreshing to see that at least the cases are being litigated and judges are actually taking these matters seriously and they're not just knocking the claims out. So I think that's a good thing.
Petrie says qualified immunity could come up and be reconsidered as the case continues to move forward and new information becomes part of the case. In the meantime, he tells us a settlement could happen anytime, Lindsay.
Callan, thank you for the update.